Hi everyone. Today's session is on the unit that we'll be doing today is the English legal system. So just a little bit about myself before we start on to the session. My name is Shazia Khan, and I'm the head of law for UK Varsity. I've been teaching law on different undergraduate programs and postgraduate programs for law for the last 16 years. So I've got an extensive experience in the different areas of law. I've also got a degree from in international and business law and a master's in international and European law. The area that we'll be doing today in regards to your session will be the English legal system. We'll look firstly at the module specification in regards to what the expectation is on this unit, and also look at the different learning outcomes. So today we'll be looking at learning outcome 1. So firstly, I'd like to look at the unit aims, which is to provide an overview of the English legal system and to prepare the learners for more substantive study in areas of English law. It's the level 3 unit, and it is credit values of 15, and the unit grading is a pass, merit or distinction, and the assignment guidance is in accordance with the organisation guidance. And today we'll be looking at learning outcome 1 is to understand the key principles of English law. Okay, so now I'm just going to share the slides with you. So we're going to be looking at the unit which I've mentioned earlier, which is 3.27, the English legal system. Learning outcome 1, which is to look at understanding the key principles of English law. We'll look at explaining the different methods by which laws are made. We'll differentiate between criminal and civil law, differentiate between public law and private law. So 1.1 will explain the different methods by which laws are made in the UK. And this is the main way that laws are made, but also in regards to the main body that deals with all this, which is the Parliament in the UK. So we've got stages in English law. This diagram identifies the different stages that a law must go through when it's being considered to be passed. So firstly, you'll have the introduction stage, the first reading, the second reading, the committee stage, the report stage, and the third reading, which will go on to the first reading, second reading, committee stage, the report stage, and the third reading. And then it would go on to once both the House of Commons and the House of Lords have approved the bill, then the Prime Minister presents it to the monarch, the head of the country, which is the King. And once that is approved, then it will be signed, and this is referred to as royal assent. Now we'll go through the procedure a little bit more, so you've got an idea of how everything goes through before a bill is being passed. So firstly, bills starting in the House of Commons. So a bill is a proposal for any sort of new laws that need to be put through, or a proposal to change an existing law. presented for debate before Parliament. So, for example, if there's a law in place that identifies there's a need for issues relating to anything to do with terrorism, and new changes need to be brought into place in regards to terrorism, or if there's anything that's happened that's in regards to terrorism that needs to be identified, or any sort of changes need to be made. This is a proposal that's presented and debated before Parliament before it goes through these stages. A bill can start in the House of Commons or the Lords and must be approved in the same form by both houses before becoming an act. So the bill started in the House of Commons with the first reading, which is the first stage of a bill, passage through the House of Commons, usually a formality, and it takes place without a debate. The first reading of a bill can take place at any time in any sort of parliamentary session where there's discussion, and the bill is published at the House of Commons for the first time, and then it's gone on to the second reading, which is mainly the first opportunity for MPs to debate any sort of issues around the bill or any sort of principles or themes around the bill. We've got the second reading, and this is the first opportunity, as I mentioned earlier, for the MPs to debate this bill. It normally, usually, as it states there, takes no longer than 2 weekends after the first reading. The government minister spokesman, who is for the MP responsible for the bill, opens the second reading debate, and then the spokesman responds with their views on the bill. The debate continues with the opposition party and the backbenchers giving their opinions, whether they feel that there's a need for the bill to go through or whether they need to proceed to the next stage, because, you know, it's where the debates start, if there's a need for the bill or if there's no need for a bill. And an example I'll give you in regards to a bill that was passed a couple of years ago, which was the mobile phone bill, in the fact that you should not be driving, you should not be using a mobile phone whilst driving. And then there was debate around that in regards to what the implications of that would be. So these are debated at this stage with MPs, and whether they need to go to the next stage in regards to whether from the second stage they need to proceed on to the committee stage. So the next stage, once the bill has been debated and once the committee, it's been passed on to the committee stage, this is where detailed examination of the bill takes place. So it's more in depth, and it takes a couple of weeks because there's, you know, or maybe longer in regards to finding out more detail about the bill and whether there's a need for the bill. So they'll be able to take evidence from experts and interest groups from Parliament, and any sort of proposals for change for discussion are selected by the chairman of the committee, and only members of the committee can vote on the amendments during the committee stage. So the amendments are proposed by the MPs to the bill, and it will be published daily and reprinted, and then they have to go to the next stage, which is again carrying on with the committee stage, where every clause in the bill is agreed, changed or removed. So if there's anything that they feel like that needs to be removed from this stage, then they will remove it at the committee stage and get everything right before they go on to the next stage. A minority of the bills are dealt with by committee of the whole House. So it takes place on the floor of the House of Commons with every MP able to take part. The bill fast-tracked through the House of Commons, which received less consideration. If the bill has amended, the bill is reprinted before the next stage. Once the committee stage has finished, it is then the bill returns to the House of Commons, and then it goes to the next stage, which is the report stage, where the amended bill can be debated with any sort of further amendments or proposals. So the report stage gives MPs an opportunity on the floor of the House to consider any sort of further proposals for change to the bill, which has been examined in the committee stage. There's no set time between the end of the committee stage and the start of the report stage. All MPs may speak and vote for lengthy or complex bills. The debates may be spread over several days, and all the MPs can also suggest any sort of amendments that need to be made, any sort of clauses, or they think any sort of things that need to be added onto the bill. And then the report stage is normally followed immediately by debate on the bill's third reading. And this, the third reading is the final chance for the Commons to debate the contents of the bill. It usually takes place after the report stage as the next item of the business on the same day. Debate on the bill is usually short here and limited to what is actually in the bill, rather than as a second reading, what might have been included. So amendments, proposals for change cannot be made to a bill at a third reading in the Commons. So all that needs to be done at the report stage and at the third reading and through the process of the committee stage. All these need to be done. They can't be done at the third reading. At the end of the debate, the House decides whether to approve the third reading of the bill. If the bill started in the Commons, it goes to the House of Lords for its first reading. If the bill started in the Lords, it returns to the House of Lords for consideration of any amendments the Commons have made. So the bills that are starting in the House of Commons, the first reading in the Lords. First reading is the first stage of a bill's passage through the House of Lords, usually a formality. It takes place without debate. The first reading of the bill can take place at any time in parliamentary session, and the long title is read out at the member of the Lords in charge of the bill. Once formally introduced, the bill is printed. Next stage is the second reading, and this is the first opportunity for members of the Lords to debate the main principles and purposes of the bill. Bill starting in the House of Commons, the second reading, and in the Lords. Second reading is the first opportunity for members of the Lords to debate the key principles and main purpose of a bill, and to flag up any sort of concerns or any sort of specific areas where they think that any sort of amendments or changes are needed. Before a second reading debate takes place, members would like to speak and add their name to a list, which is called the Speakers List. The government minister, spokesperson, or a member of the Lords responsible for the bill opens the second reading debate. Any member can speak during the second reading. This stage can indicate those members particularly interested in a bill or specific aspect of it, and those who are most likely to be involved in suggesting changes at later stages. Second reading debates usually last a few hours, but sometimes they can stretch over a couple of days. After second reading bill, the bill goes to the committee stage, where detailed line-by-line examination and discussion of any amendments takes place. Bill starting in the House of Commons, committee stage, the Lords. Committee stage involves detailed line-by-line examination of the separate parts, any sort of clauses and schedules. Starting the front of the bill, members work through to the end. Any member of the Lords can take part here. Usually starting about 2 weeks after the second reading debate, committee stage generally lasts up to 8 days, but can go on for longer. Before committee stage begins, any sort of amendments or anything are gathered together and placed in order, then published in the marshalled list. Updated lists are produced before the start of each committee stage. And this is to identify if there's any sort of amendments to be made. The committee stage, Lords, during committee stage, every clause of the bill has to be agreed, and to vote on any sort of amendments can take place. All suggested amendments have to be considered. So if a member wishes, members can discuss an issue for as long as they want. The government cannot restrict subjects in the discussion or impose a time limit. This is a key point of difference with procedure in the House of Commons. And if the bill has been amended, it is reprinted with all the agreed amendment, and at the end of the committee stage, the bill then moves on to for further scrutiny. So the report stage in the Lords. Report gives all members of the Lords a further opportunity to examine and make amendments, changes to the bill. It usually takes 14 days after committee stage is concluded. It can be spread over several days. And the reason around having all this, the stages they go through is that if there's anything that someone has missed, or if there's anything that needs to be amended, it goes thoroughly and rigorously goes through these stages to identify any changes or any amendments that need to be made before it actually goes to get signed by the King for royal assent. During the report stage, detailed examination of the bill continue. Any member of the Lords can take part, and votes on any amendments may take place. After the report stage, the bill is reprinted to include all the agreed amendments. The bill then moves on to the third reading, a further chance for the Lords to discuss and amend the bill as it nears conclusion. If the bill is amended, it is reprinted to include all the agreed amendments, and this then moves on to the third reading. The third reading in the Lords is the chance for members to tidy up the bill. So here they concentrate on the eventual laws, whether there's any sort of workable laws in place, and whether there's without any sort of loopholes or anything. So before third reading, the amendment changes are gathered together and placed in order, then published in the marshalled list. Unlike the House of Commons, amendments can be made at third reading in the House of Lords, provided the issue has not been fully considered and voted on during either committee or the report stage. So we've got the third reading Lords amendments. So amendments at third reading are often used to clarify specific parts of the bill and to allow the government to make good any promises or changes they made at early stages of the passage of the bill. If the bill started in the Lords, it goes to the House of Commons for its first reading. The House of Commons reprints the bill with Lords, and then if the bill started in the Commons, it is sent back after third reading to the House of Lords for consideration of Lords amendments. Or if there are no amendments in the Lords, it is sent to the King for royal assent. Consideration of amendments. When a bill has passed through third reading in both houses, it's returned to the first house where it actually started for the second house's amendment proposals for change to be considered. Both houses must agree on the exact wording of the bill. There's no set time period between the third reading or the bill and consideration of any Commons or House of Lords amendments. If the Commons amendments to the bill, the Lords must consider them and either disagree or agree to the amendments or make any sort of alternative proposals. And that's why the House of Commons and the House of Lords work together to get these alternative proposals in place before it is sent for royal assent. A bill can go back and forth to each house, and this is referred to as ping pong until the houses reach an agreement. And the reason for this is that they want to, as identified earlier, they want to be quite rigorous in what they're doing and what bills and what laws they are passing, so they are not making any mistakes or have, if there's any proposals for change or any amendments, they have gone through it in these stages to identify that, there's a need for change or any amendments to be made. Consideration of amendments. Once the Commons and Lords agree on the final version of the bill, it can receive royal assent and become an act of Parliament. The proposals of the bill now become law. Okay. In exceptional cases where the two houses do not reach agreement, the bill falls. If certain conditions are met, the House of Commons can use Parliament Acts to pass the bill without the consent of the Lords in the following sessions. The royal assent. When a bill has completed all its parliamentary stages in both houses, it must have royal assent before it can become an act of Parliament. Royal assent is the monarch's agreement to make the bill into an act and is formality. There's no time set period between the consideration of amendments and to the bill and the royal assent. It can even be a matter of minutes after ping pong is complete. When royal assent has been given to the bill, the announcement is usually made in both houses at suitable break in each house's proceedings by the Lord Speaker and the Lords and the Speaker in the House of Commons. And that's the final stage that it needs to go through. At prorogation, which is the formal end to a parliamentary year, Black Rod instructs the proceedings of the Commons and summons MPs to the Lord Chamber to hear the Lord Commissioners announce the royal assent for each bill. The legislation within the bill may commence immediately after a set period or after commencement order by the government minister. The commencement order is designed to bring into force the whole or part of an act of parliament at a date later than the date of the royal assent. If there is no commencement order, the act will come into force from midnight at the start of the day of the royal assent. The practical implementation of an act is the responsibility of appropriate government department, not Parliament. So, bill starting in the House of Lords. So when a bill is started in the House of Lords, it undergoes the following steps, as we've discussed in earlier slides in regards to the different stages that it needs to go through. So the first reading, which is in regards to the Lords, which is slide number 12. Slide 13 is the second reading, Lords. Committee stage in Lords, slide number 14 to 15. Report stage in the Lords, number 16. Third reading, Lords, slide number 17 to 18. First reading in the Commons, slide number 6. Second reading in the Commons, slide number 7. The committee stage in the Commons, slide number 8 to 9. Report stage in the Commons, which is slide number 10. Third reading in the Commons, which is slide number 11. And the consideration of amendments, slide number 19 to 20. And then the royal assent, slide number 21 to 22. So this will help you identify any sort of areas that you need to look at when discussing your assignment areas. Now we're looking at 1.2 of Learning Outcome 1, which is to differentiate between the criminal law in the UK and civil law in the UK. So firstly, we're going to look at the introduction of civil law and what that is. The civil law is a place to ensure that individuals are protected from one another and the state. The rights and responsibility of individuals are laid out in civil law through both legislation and through courts, which are referred to as common law. In some instances, an offence will fall into both criminal and civil law. For example, drivers maintain a duty of care to each other, and if one drives recklessly and causes an accident in which someone else is injured, a civil claim can be brought against the offender for negligence as well as criminal prosecution. There are requirements, considerations made by the court in civil law case. There are requirements for certain considerations to be considered before civil action can be taken. For negligence to be established in a civil law, the claimant must demonstrate that the following are present. So a duty of care was owed to the defendant. There was a breach of duty of care. The breach of duty caused an injury, damage or loss to another. The standard of proof lies with the claimant, though the demands are less than those in criminal trial, as the claimant is only required to prove that their case on the balance of probability to achieve a successful result. Civil law penalties and remedies. So under public law is a type of civil law which refers to the state's duty to protect an individual's rights from other people or organisations. As an example, the state is authorised to impose various orders against domestic abuse offenders. Orders are issued to protect the local community or vulnerable people. and antisocial behaviour orders, as both if these orders are breached, then the offender is held accountable and can suffer criminal prosecution. Penalties and remedies in civil law. There are a number of remedies that can be issued under civil law, including damages and compensation, awards, orders for specific actions and injunctions. The court will make the decision on appropriate remedy based on the particulars of each case and the action being sought by the claimant. So each individual case has its own merits. And when we look at civil law, the main focus is on concerned with the private relations between members of society. It includes matters against individuals, companies, and against the state, unlike criminal law, which is losing a civil law case won't result in then, if they lose a civil law case, it won't result in them going to prison, whereas in a criminal case, it will. Examples of civil matters that you can come across on a regular basis before we go on to criminal law is things like breach of a contract, negligence, family divorce, child arrangement orders, unfair dismissal or discrimination at work, and any sort of personal injuries that may occur. Now we're going to just go on to the criminal law, which is an introduction to criminal law. So criminal law serves to ensure that each person in the UK understands what is considered to be acceptable behaviour and conduct. So it's important that you as an individual understand, you know, what you need to, what behaviour you do on a daily basis is acceptable or not. The majority of criminal law is set out in numerous acts of parliament, such as stealing is outlined in the Theft Act, and others such as Criminal Damage Act and Offences Against the Person Act. When a person has breached criminal law, they're considered to have wronged society, and they may be liable for criminal action and prosecution from the state. Breaking a law, criminal laws will result in facing criminal prosecution, which involves a criminal proceeding normally being prosecuted, which we'll mention more about by the Crown Prosecution Service, which is on behalf of the state, whether it be in the Crown Court or the Magistrates Court. How criminal law cases proceed, as we mentioned, it goes to the CPS, which are work on the behalf of the state, and they are brought, the vast majority of cases begin in the Magistrates Court, as we stated earlier. And if the case is more serious and the severity of the case, then the offender will normally go before a judge and a jury at the Crown Court. Considerations made by the court in a criminal law case. So criminal law liability normally considers a mental element known as mens rea and a physical element that is referred to as actus reus of the crime. Mens rea may refer to the defendant's intention. So did they have the intention to do something? Negligence or recklessness with their knowledge. As an example, a case of theft, which includes the mens rea of dishonest intention and the actus reus of carrying out the theft. Once this has been established, the defendant can be convicted. The physical element of an offence does not require the defendant actually physically moves in order to carry out the crime. For instance, if for the offence of fraud, the mental element would be dishonesty and the physical element will be the defendant's false representation. And carried on in regards to considerations made by the court in a criminal law case. In some criminal law cases, such as traffic accidents or environmental crimes, it is not necessary for a mental element to be established. This means that premeditation or intent are not necessary requirements in order for the defendant to be convicted. These types of offences are referred to as strict liability offences. One of the most important aspects of UK criminal law is that a defendant is presumed to be innocent until they are proven guilty. It is that enables us to benefit from a fairer judicial system. In criminal proceedings, the criminal standard of proof is adopted, and this means that the prosecution must beyond a reasonable doubt prove that the defendant is guilty. In order to be found guilty by the courts, the standard of proof, as mentioned, must be beyond a reasonable doubt. So the jury or magistrate should consider this before making a decision. If the reasonable doubt is present, the jury or magistrate are obliged to acquit the defendant. Comparison. So if you look at this table, it identifies the characteristics, the civil law and the criminal law. The definition of civil law is civil law deals with the disputes between individuals, organisation, or between the two in which compensation is awarded to the victim. And then when we look at criminal law is a body of law that deals with the crime with the legal punishment of the criminal offences. The purpose of civil law is to deal with the disputes between individuals, organisations, or between the two in which compensation is awarded to the victim. And the purpose of criminal law is to maintain the stability of state and society by punishing offenders and deterring them and others from offending. The jury opinion in civil law is, in cases of civil law, the opinion of a jury may not have to be unanimous. So laws vary by state and country. Juries are present almost exclusively in criminal cases, virtually never involved in civil actions. Judges ensure law prevails over passion. The jury's opinion in criminal court cases is that in criminal justice system, the jury must agree unanimously before a defendant is convicted. In civil cases, the case is filed by the private party, and in criminal cases, it's filed by the government. The decision in civil cases is defendant can be found liable or not liable, and the judge decides this. And then in criminal cases, the defendant is convicted, if guilty, and acquitted if not guilty. The jury decides this. The standard of proof in civil cases is preponderance of evidence. Claimant must produce evidence beyond the balance of probability, and beyond in criminal cases, it's beyond a reasonable doubt. In looking at, carrying on from the table and looking at the burden of proof in civil cases, the claimant must give proof, however, the burden may shift to the defendant in situations of res ipsa licita. And then in criminal cases, the burden of proof is innocent until proven guilty. The prosecution must prove defendant is guilty. The types of punishment. So for civil cases, you'll get compensation usually financially for injuries or damages or an injunction in nuisance. For criminal law cases, a guilty defendant is subject to a custodial sentence or non-custodial punishment, which is things like fines or community orders and tagging in exceptional circumstances. The death penalty is not always the case in the UK. Examples of civil cases, civil law is things like landlord and tenant disputes. So if they've got like trying to get rid of evicting the tenant, any sort of proceedings against child custody proceedings, divorce proceedings, property disputes and personal injury cases. Examples of criminal law cases is things like theft, assault, robbery, trafficking, murder, manslaughter, sexual offences, supply possession of drugs, things like fraud as well, money laundering, GBH, ABH, these would fall within the criminal law side, any sort of criminal damage or affray. The appeal system in regards to civil system, either party, the claimant or defendant can appeal a court's decision. In regards to criminal, only the defendant may appeal a court's verdict. The prosecution is not always not allowed to appeal. The commencement of proceedings. So when we look at the commencement of proceedings for civil law, it's the state of people prosecution by summons of indictment. When we look at criminal law, it's by way of the pleadings representatives of the state, prosecutor and the attorney general. Now we're going to go on to looking at the differentiating between the difference between public and private law and the importance of this. So in introduction to public law, first law, public law is the administered the relationship between the government and individuals. It comprises of standards governing the relationship between various branches of the government and the rules administering the relationship between government and the people or private bodies. Public law comprises of constitutional law. This is related to the constitution of the country. It is especially concerned with three branches, which is the legislature, judiciary, and the executive. Then we've got administrative law, and this is the law governing the functions of the government and its roles it plays for citizens. This area of law is such as trade, economy, public service, environmental protection, and taxation. Then we've got criminal law, and this is concerned with the punishment of offenders. Significance of public law. So the public law sets out the powers and obligations of governments and categorizes the rights and obligations of people to governments. It is believed that public law is an area intended to encourage and promote the common good for the benefit of the community. Public law tries to ensure that public interests of the general population, since the abusing the public law would affect the community. The sanctions imposed for violations are considered to be severe in nature. For instance, the sanctions under criminal law could vary from fines, custodial sentence, and to death penalty. How do public bodies derive their legal authority? Generally, public bodies and authorities derive their power to make decisions and for action, inaction of them from the acts of Parliament. So anything that, because Parliament is the supreme making body, we refer to the acts of Parliament. These are often called statutory powers and obligations and can be found under one or more of the below listed sources, which is legislative enactment of Parliament, Gazette rules, Gazette orders, rules and regulations enacted by ministers under the authority granted by Parliament, regional community law, which are things like directions and regulations made by legislative bodies, public policy, so these are rules and procedures of a government. It holds no citizen can do anything that would be harmful to the public as stated by the government. So what are the remedies under public law? So we've got what are the public wrongs? Public authorities need to act in accordance to the public law principles. So this implies that they have to follow some of the few principles. Function legitimately, which means public authorities must follow the law. They must not misuse their power, which is abuse of power, or do anything which is not legally authorized to do so. They must act rationally and reasonably and follow the procedures and policies in place. The remedies under public law, one of the most common remedies under the public law is the judicial review, where the judges appraise the legality of the actions and the resolution of public bodies. In addition, other methods of settling grievances include things like appeals, inquiries, private law actions, any sort of internal complaints and procedures to the Parliamentary Commissioner for Administration, which is the local ombudsman. Now we're going to go on to look at private law. So private law is the body of law which governs the relationship between private individuals. Private law categorizes the rights and obligations of people and private bodies in their relationship amongst the either. It covers various areas such as contracts, property, equity and trust, tort, succession, and family law. The private law ensures the freedom of people to pursue their aims and goals. The legal relations enable the parties to act freely in their private capacity or private individuals. The private law tries to secure just private interests, freedom of the individuals in the community. Most of the remedies in private law are of pecuniary monetary nature, which is money. The party who has infringed the law needs to pay some amount of cash to the injured party and not to the state as determined by the courts. So private law, the classifications, if you look at that, is the law is at the top, and then we've got public law and private or civil law, which is the public is constitutional, administrative, criminal, and then we've got private, which is contract, tort, property, trust, and family. Features of private law. The private law is categorized by evidential, procedural, and doctrine guidelines that oversee any issue between particular parties, claimant and the defendant. The defendant, the party who claims to have been wronged, brings an action against the defendant who is alleged to have committed a wrong. If the court discovers that the defendant is in charge of wronging the claimant, the defendant is obliged to make good for the claimant's damage, harm, generally by providing a pecuniary compensation or restitution. In private law, the claimant is not ready to bring an action against anybody other than the defendant. Thus, private law forms a relationship between the claimant and defendant for having purportedly wronged the other. Features of private law continued. The claimant and defendant under the private law can be private individuals, business organizations, or any other party acting in the capacity of a private person. And such disputes may have occurred only between the claimant and defendant, where they could either conform or repudiate the alleged wrongdoing. Thus, the state's role in the area of private law is limited to providing a systematic mechanism for resolving disputes between claimant and defendant. So some of the remedies and sanctions available under private law. So restitution, which is in integrum restitutio. This is where the party alleged to have breached the law will have to restore any matter to the state condition as a breach of law had never happened. For example, if the supplier of certain goods hasn't received the payment for a buyer on a specific day as stated in their contract, the court might order the buyer to return the goods bought to the supplier since the buyer has breached their contract. Damages and compensation, an amount determined by the court will have to be paid to the other party in order to compensate for the actual damage or loss of profit by the injured party. In private law, the remedies and sanctions again, returning enrichment, which is where the party who has breached the law has benefited unjustly. It is known as unjust enrichment. The court will determine the amount of unjust enrichment to be paid as compensation. Then we've got specific performance. Here, at times, the private law may recommend a remedy to be of non-pecuniary nature. In these circumstances, it's not the payment of money that is required, but the other party ought to do or give something up, for example, specific performance. An example would be if the supplier of certain goods had breached the contract to deliver X, it will be ordered by the court to honour the contract and have the goods X delivered to the buyer. Some of the references are, we've finished in regards to learning outcome 1, and we've looked at the issue regarding how a bill is to be passed through Parliament. We looked at the difference between criminal and civil law, and we identified the difference between private and public law, and in regards to any sort of remedies and sanctions that are available for individuals, and also looked at the principles of the English legal system. And we've completed learning outcome 1 now. Some of the references are available here for you to go on, and also additional resources are available for you to go on Moodle. So we've got the UK public law and European law. We've got the J. Hodder principles of criminal law. We've got the interpretive precedents, the rule of law, and English legal system by Pearson Education. So have a look at these resources. Some of these resources are available online for you, but go on to Moodle to get your resource, get your additional reading. Some more resources just there for you to look at in your own time. So we've finished learning outcome 1 now, and thank you for attending the session, and we'll be moving on to learning outcome 2. Thank you.